Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about executing estate planning documents in the current environment where we face with COVID-19. My state, presently, the governor just signed a stay-at-home order, and so people have been reaching out, wondering how they can put their estate plan in place, and can we do these execution of these documents remotely. They hear about online notarization and all these good things, and so phones have been ringing with inquiries about this. So I wanted to take an opportunity to make a video to talk about what it would look like to put your estate plan in place at this time under the current conditions that we have with the concerns of COVID-19 in Florida, and particularly here in South Florida where I reside. If you wanted to take an opportunity to connect with me personally, you can do so at eldermeeting.com. That's where you could schedule a free 30-minute slot to talk to me over the phone if that's something that you wanted to do. So I wanted to talk about executing estate planning documents in the current climate that we have with this health concern that our nation and the world is facing. So the estate planning documents that I think most people, most every person should have in place is a healthcare surrogate, a power of attorney, and if you think it's appropriate for you, you may want to have a last will and testament or a revocable living trust. Those would be the estate planning documents that the average adult would want to consider if they were wanting to engage in estate planning. So right now, as we sit, there is no opportunity for online notary or electronic wills in Florida. There is legislation that has been passed, but it does not come online until July 1st, 2020. It is not yet July 1st, and none of the legislation or emergency orders that have been passed have advanced that date. So that means that only notaries in person, we can't do online notaries right now in Florida for electronic wills. So let's just put that out there. And really the big issue, the hurdle that's facing Floridians at this time is not so much the lack of online notary, but it's the fact that our estate planning documents require witnesses. And these witnesses need to be in your physical presence. So for us to be able to execute, for instance, a designation of healthcare surrogate, the principal, meaning the person who's creating the document, needs to sign it in the presence of two adult witnesses. And these witnesses can't be related. So that's one of the rubs that we have right now with executing estate planning documents. We have to be cautious and creative when we are doing this, but we cannot get around the fact that we need physical presence to lawfully execute these documents. So if you want to execute a designation of healthcare surrogate, that's the document that allows another person to speak on your behalf to medical professionals should you not be able to speak for yourself. You will need to be able to sign that with two witnesses present. The other document, the power of attorney for financial decisions, also requires two witnesses. You need to sign that document in the presence of two witnesses, and that document also needs to be notarized. And while there is a provision that that document could be notarized with somebody using an online notary service, there's no provision to get around having physical witnesses present. And the online notary law, the provision that allows for online notary in Florida, specifically excludes the statutory superpowers, which a good durable power of attorney that would provide you with the most opportunity to avoid guardianship, which is truly the purpose of a durable power of attorney document, is that you want to have your agent be able to make all sorts of legal decisions for you and financial decisions for you, so that way you do not need to petition a court for guardianship. Those statutory superpowers cannot be elected through the use of an online notary. So you would still need an in-person notary, as well as your physical witnesses. So that document as well, you would need to be able to sign in front of people physically present. With regards to wills, at this time, we don't have electronic wills in place in Florida, not until July 1st, 2020, and that can be its own video as to what an electronic will look like in July 2020. And so you still need witnesses for a will. If you want to prepare a will, you need yourself to sign in front of 2 adult witnesses that are not related to you. For that will to be self-proving, which any estate planning attorney would be recommending that you have a self-proving will, because when it comes time to probate that document in court, it makes it that much easier to admit your will into probate if it is a self-proving will. And a self-proving will not only requires your witnesses, it requires a notarization. So you would need an in-person notary at this time, because we do not yet have electronic wills online here in the state of Florida. Likewise, if you wanted to have a revocable living trust put in place, you will need witnesses in physical presence and a notary as well. And so we are still drafting estate planning documents here in the state of Florida, and practitioners have many ideas and safety precautions that we can put in place in an effort to comply with the law, to have witnesses physically present in the line of sight, that we can see you sign and we verify that you are who you are and that you know what you're doing. And we stay distant yet near enough to witness and see, and we can bring notaries. They even with the governor's stay-in-place order, legal services are an essential business, and it's an essential thing, and therefore we can do that. However, it is something that each individual needs to do with caution, because the last thing that we want to do is cause anybody unnecessary exposures and unnecessary contacts. So really, what it's important for you to do is to see if you do have any estate planning documents already in place that you think are just old and out of date. It might be a good time for us to review them and see, what does it really say, and is it truly is it still something that could be useful and meaningful to you now, and it's better than having nothing in place. I'm happy to take a look and talk to people about some of their old documents that they have concerns with. And I'm also happy to talk to people about putting in place provisions for them now, if that's something that they are super concerned with and they want to proceed in that fashion. We can have that conversation. But it's really important for people to understand that these documents, they require witnessing. There's no workaround to be able to have a Zoom witnessing type of execution at this time for these documents in our state. And you need to make informed decisions and make sure that you understand any risks that might be to yourself. And of course, the notaries and the witnesses themselves have to make informed decisions to whether or not they want to take on those particular signing jobs. So I hope that this information has been helpful to you. If it has, I ask that you like and share with others. And again, if you want to jump on a call with me to talk, I'm here. I can take I'm happy to schedule an appointment. You can book yourself at eldermeeting.com, and we can jump on a quick call for 30 minutes max and talk it out. Okay? Again, thank you for joining me.